This material is made available to you by or on behalf of the University of Melbourne under Section 113P of the Copyright Act 1968. It may be subject to copyright. For more information, visit the University Copyright website.
Okay, just as the last few people come in, we might get started. We are in week 11, and I don't know about you, but I'm feeling the strain. 2 subjects I've got to teach, you've got to take 4, some of you I know. So let's make it as easy on ourselves as we can. I've got a bit to cover today. I want to run through some key things you should know about amendments in a bit of a reminder to start with, and some key things in a more legal sense about the dimensions of that. We'll be referring to case law, and I won't go through absolutely everything shown on the slides, in favour of also talking a little bit about the second assignment. And I won't give you all the answers, but I'll take you through some steps that will assist people who feel a little bit all at sea, I suppose, because I understand that it may not be completely familiar to them, or they might be brand new to the process. So, at least it's warm in here, or I'm warm anyway. It's not too bad. Okay, so thinking about amendments, thinking about ministerial interventions in the process, and how it is quite common to have legal principles underlying a lot of the things that are happening in the planning system, and reinforcing the point that not understanding some of these key principles might be at your peril in many ways. So we'll talk about that as we go through. So as a bit of a reinforcing exercise, thinking about what amendments are, well, it's to the VPPs itself, that fundamental template might be to that, changing the whole thing or parts of it across all of the state. It might be changing just parts of the state planning policy framework, the LPPF, or perhaps just controls applying to particular land. It usually is the zones or the overlays that relate to that. So hopefully this is not deeply surprising, but just a reinforcing exercise. And what is really an amendment? Well, they are significant, and they're not taken lightly, as you'll see in the way that we deal with problems of process under Section 39 of the Act. They are, in fact, a form of subordinate legislation. What we mean when we say that, we have legislation, the laws of the state, in this case, passed by Parliament, and then because in here it says, forming part of the VPP's planning schemes, etc., the planning schemes sitting underneath that are subordinate legislation. So they're important legal documents, and we do take them very seriously, if only because people's rights are significantly modified in terms of what they can do or can't do, but also because there's a lot of money involved, but also this thing of natural justice and undertaking processes with the due diligence that we need to pay heed to with those things. So the force of the planning scheme comes from the Planning and Environment Act and a number of other associated legislation. The content of planning schemes, while some of it is up to planning authorities to take charge of and take a lead on what they want for their own, so like local councils, for their own purposes, a lot of the content is also dictated by the planning scheme, and indeed the processes that we go through to modify that content are set out exhaustively in the Act. So it is a complex process. Don't be overwhelmed by that. If you understand the key steps of a planning amendment, then you can kind of branch out and get into the complexities. So I guess the other thing to think about is how the Act, under, is it section 13? Let's check if I'm right. Who knows what section 13 is? Responsible authority. So, no. Section 12, Alan. What are the duties and powers of planning authorities? Okay, so this means that the creation of a planning scheme, its modification, kind of comes from that section 12 and the rest of the planning scheme associated with it. So the point here, any amendment is in itself legislative and accordingly is taken very, very seriously. So generally, all of those little steps are falling into three kinds of phases. The planning phase, the gestation, the considering it, should we do it? Is it worthwhile? Is there another way of doing it without changing the planning scheme? All of those things. Why have we got 4 there and I say 3? Okay. 4 things. It's like Monty Python sketch, if you recall that one. Public engagement, and in fact, that might also include a range of other agencies of government. So you could include all of the various agencies that might have some interest in it, including their ministers often. The panel process, which is an independent review body. It makes recommendations after investigating the matters before it. Alongside it is a whole bunch of political processes. The Act doesn't really discuss them, but it acknowledges one key political player at some length. In here we're going to be talking about tonight. There's probably 2 main players politically in here. Who do you think they are? Politically. Minister, bang on. And the other political player, which has a whole bunch of other roles, is the councillors, as in the politicians who are elected members of a council. So while the Local Government Act, another Act of Parliament, sets out a whole range of responsibilities and processes for local government, and a lot of those are unchangeable, I suppose, it is also worth noting that local government can be incredibly political sometimes because they have voting, they have local issues. You probably see them in the Leader or these local newspapers. They're massive at local government level. So we're running a process where all of these steps are set out here, but then councils come in at certain stages and make very political decisions, because that's democracy, and ministers come in at various times. We're not going to be talking about councils tonight, but we are going to look in a couple of instances at the minister's power and think about how extensive that is, but in fact that there are also some limits to that power. So, why are amendments made? Clearly, at 2 levels, I suppose, we could think about at state government level, the minister might want to change the policy according to him or her being a member of the government of the day. So it could be to facilitate growth, could be to introduce a new policy for all of Melbourne, like Plan Melbourne. Initially, one of the big changes we had was this whole swing towards metropolitan planning again when Melbourne 2030 was introduced. That's 15 years ago now. So that government can govern in whatever you think of that. So it's allowing the government to govern, but it can't just do whatever it likes willy-nilly. It still has to comply with the Act in the way that it changes the planning scheme. And to give effect to established policy. Oh, I've lost that. There we are. So it could be that local government sets out a future course where it might be saying something like, we need to protect existing industrial land even though it's not really being used because we're worried about where our workforce will be working into the future. So we're going to change the planning rules associated with these old semi-redundant industrial uses and make sure they stay industrial. And so on and so forth. So many things. It could be about heritage. It could be about trying to focus development on activity centres and so forth. So lots of reasons, and again, it's going back to the fact you've probably discerned by now, while the Act does stop a lot of things happening, on balance, it is trying to facilitate development. That's the focus that is imbued within this. It is a pro-development document. And then, of course, circumstances change, don't they? You can see over the years that we care, I hope, more about the environment, more about aesthetics and amenity, we care more about bikes, etc. You'll see all those things have been introduced slowly into the planning schemes by way of scheme amendments. And then some things are taken out. Although if you look at the planning scheme, which is about that thick, it looks like we're just mainly putting things in to me. And of course, implementation of strategic objectives, built form outcomes like height limits, you name it. So we've got a very complex system because we kind of want everything. We're trying to do it through a set of rules. So who can be a planning authority? Under Section 12, Municipal Council, that's the City of Yarra, the City of Moreland, etc. The Minister can play that role. And sometimes statutory authorities will take that on. Port of Melbourne might be a good example, where they're the planning authority for their particular sort of area of jurisdiction. How does an amendment start? Well, probably the most common way is either council wants to do something, or the owners of land or people with an interest in land want to do something and they need to change effectively the rules that apply to land. So, the most common example, particularly in a city, heritage studies are often, or streetscape studies are often a good driver of scheme amendments. Or the City of Melbourne, you've probably noticed in recent months, has been doing a lot of work about street level amenity and activation of street fronts. They've made quite a few changes recently about that. I think C308, if you want to have a look at that. So, basically doing things at local government level. But some of the big drivers, someone might own land and they think, well, we want to do a thing that we believe is in accordance with the responsible authority's intentions, but the planning scheme won't let us achieve them. So we're going to go to them in their planning authority role and ask them to change the rules. So as market-based things change, as the city evolves, as development occurs, it might be seen that there's a need to change things to facilitate things, and it's not uncommon for a local authority to be given an opportunity to do something. A new industry comes to town and they really want to, yes, we want that industry for employment. They often become quite interested in changing the current rules. That said, perhaps a word of warning, if you're acting for a client or if you're working in council, there is usually an aversion to starting a scheme amendment unless it really makes sense. So in a background way, the VPPs, first introduced in 1999 onwards, were intended that there would be much less scheme amendment stuff going on because there was increased flexibility in the zones, so as to discourage rezonings. When I first worked as a planner in Western Australia, a little while ago now, we would almost have daily rezoning processes going on. But one of the problems with that, in a very old-fashioned, cumbersome planning scheme, is that it reduces the ability to have strategic overview and direction. So it made the system quite clunky, and it took a lot of work. So the VPPs, one of the premises is that there's enough flexibility and enough strategic policy, particularly in state planning policy and the LPPF, to drive direction without constantly changing the rules. And I think generally that's a good idea. The fact we now have such a complicated system is probably one of the downsides of that. I suppose the other thing it did was to take planning out of the control of local government in many ways. So if state government, you're required to use in the planning scheme a lot of provisions that are just derived straight from state government. It prevents local government doing things that state government doesn't want it to. So advocates for local government empowerment are not necessarily very pleased with the way the VPPs work. So we have two types of planning scheme amendment. There's the ordinary process and what we call the extraordinary process. Does anyone know what the extraordinary process would be called? I know you want to tell me. No? 20 Part 4 of the Act. We're going to talk more about that tonight. And essentially, we call it extraordinary because it doesn't go through all of the steps about public notice, about submissions, etc. Essentially, it's just the minister running the process without extending advertising or submission rights or oral presentation rights or the appointment of a panel. So it's quite extraordinary in a way when you think how exhaustive the other steps are. There's this other, much quicker way. But we'll have a think about that in a bit. So I won't go through this in great length in the interests of getting through the material tonight and letting you ask me questions. But and we've been through this already. But in this case, we have the particular sections of the Act down on the PowerPoint slides. So if you were answering an exam question about the different steps, it may well be advantageous for you to mention the relevant bits of the Act if I were to pose you a question about what's the first step in the formal process, and so on and so forth. So I won't labour that point, but you've got this as a fantastic resource in that way. Or am I just tricking you? I don't know. So it won't hurt to know it, will it? It's one of the two fundamental processes in the Act. So, but you can see here one of the processes, one of the starting processes that many people forget or are not fully aware of, is that recently, or relatively recently, 2013, we had another step, which is that the minister must agree to the commencement of an amendment. Previously, local government could commence an amendment process and without any sort of overview from state or ministerial level, and it was revealed that many planning authorities were starting amendments that had no real chance of succeeding right through to the end for very political reasons, to show residents, yes, we're on your side, we're trying to help you, and I have sympathy for that. But it turned out that many of these processes were started and they clearly didn't fit in with the existing policy framework, but councils were sort of getting local residents off their back by saying, oh, well, you know, the minister failed, you know, stop the process from going through at the very end, it's not our fault. So this kind of short circuits that and saves huge amounts of resources. On the other hand, is the minister excessively controlling about this? You might have to decide yourself and have a look at the relevant parts of the Act to think about whether his or her powers are too great there. So then we have the preparation of amendment, all of the documentation. It might be very simple or it might be very, very complex. Public exhibition for 60 days. If it is appropriate, the minister might grant exemptions if it's not a non-contentious case or there's some urgency about it. People have a potential to have a say. Submissions. Now you'll notice something about this, it's different to the wording used in the permit application process. So if you think of this as one of the public consultation bits, there's a difference. What do you reckon that is? I mean, in the permit process, it's an objection for a start. So what do you reckon the implications of that might be? Yeah, you can. You can be supportive. It's actually a more complex and sophisticated way. And it might express support about parts and some concerns and objections to other parts. And this goes with the general idea of amendments as a productive problem-solving exercise. So we're trying to really move away from a court-based system here to more a group of expert panellists considering something in its entirety to try and improve outcomes. So you can certainly, you know, have mixed things in there, pro and con. But generally speaking, we're mainly getting people opposing through those submissions. So then the planning authority must consider the submissions. They might be for or against or a whole mixture. Then they've got the choice just to give up. Say, look, there's too much opposition, or actually someone pointed out something we hadn't thought about and now we've got that in our mind, maybe we give up because it doesn't make sense. Or they might change it. Or the most common thing is that someone has opposed it, at least partly, and they are required by section 23 to refer the submissions and indeed the whole amendment to a panel, a planning panel. So when you have a hearing, the hearing will let everyone have a say. This might be very fast if it's a small matter, or it might go over several weeks. And the nature of the hearing is generally quite relaxed. They still pay a lot of attention to natural justice and letting everyone have a say. But they, if you know, on the tea break, it's perfectly okay to have a chat with people or even the members. You know, what have you been up to on the weekend? All those sorts of things. Whereas in the tribunal, that would probably be frowned upon. The tribunal members disappear into their own chambers, kind of in a more legal court sort of way. But in the panels, you might be in country Victoria, and you think, what are you guys doing for dinner? Oh, let's all go out. You know, so while one would be careful about looking as if you really are, you know, you are partial, it's not quite as rigorous as the VCATs, or certainly not as vigorous as a court system. So, the panel members are, this is sometimes, and we're going to talk about this a bit more tonight, the appointment of panel members is sometimes contentious, but essentially it's the minister's job. The minister is advised by DELP, and mainly Cathy Mitchell, and she was actually the panellist in my first planning panel presentation, and she kind of gave me a couple of raps over the knuckles because I wasn't doing it properly, and she said, Mr. March, pre-PhD, Mr. March, you don't have to tell the panel what an industrial one zone is. Move to the facts of the case, please. And so they will guide what happens, I guess. Clearly it stung me a bit, I still remember. But it was indeed completely appropriate. So they run it to essentially imagine a group that is investigating a matter, and they've invited people to come and tell them things that might be relevant to that matter. So they'll say, okay, I see that your submission is pretty much identical to this one, so if you just summarise it, please. Do you have a problem with us sort of moving fairly quickly because it's the same, or actually can you stop and go back a bit? I think this is really relevant, I'm going to dig into it more, and so forth. So it's quite an investigative process where they seek to make themselves informed. And indeed, they might do a whole heap of preparatory work, and they might even ask the different parties to bring certain information to them. So if they think, you know what, there is an environmental matter here, we would like a hydrologist's report, you know, and so on and so forth. So you can see it's not adversarial in the way courts work. It's quite different. It's meant to really be professionals trying to come up with a really sound bit of decision making. But it still has to be within the Planning Act, and it still has to be within the VPP format and the nature of the planning scheme's adaptation of the VPP format that it's relevant to. Huge amount of sessionals. I'm regularly asked to become a sessional member. I haven't because I have a day job, but I'm tempted sometimes because it's kind of interesting to just go and work on one thing without the phone ringing and all that. But so who knows, you may well find yourself being a panellist if you go further in your career in that direction. So it's not bound by the rules of evidence like a court, but it does have procedural justice as one of the most fundamental elements to how this works, right alongside the Act. So there's two main areas there that are super important. And if you're doing things, even if you're not the panel member, you really do need to be aware that these two fundamentals underlie the conduct of the panel. Bias rule and the hearing rule. The bias rule is that independence must be a driver for the panel members and their conduct, and some key words here, no real or perceived interest in the case. So real interest would be, actually, I own a bit of the land that's relevant here, or someone just it might look problematic. So there's a sort of a maxim, not only must justice be done, it must be seen to be done. So that also invokes a certain amount of transparency and openness to the way conduct occurs. So this is sometimes, you know, a bit exhaustive, but it is necessary, because if we don't follow that principle, it undermines the believability, the value of decision making. So, you know, someone must be capable of bringing an open mind to the issues. So they must be free of actual prejudice or the perception of prejudice. Now, pretty subjective, aren't they? Kind of challenging. So, let's have a look at Mildura versus Minister for Major Projects to investigate that. And I won't... Oh, it looks like the touch panel has lost connection. Oh, that's no good. I don't know how we lost connection. Is it part of that? Could that be? You know what, guys? Do you want to just pause for a minute and I'll call, because I was planning to use this a heap, and I just need a telephone. 40777. So if you want to stretch your legs, do so. Hopefully this doesn't take too long. if they'll say turn it off and turn it on again. Have a look at that. See if you can.
It's just an iPad.
No, it's not as good as an iPad. That's for sure.
No, it is an iPad.
Is it really?
Yeah, it is just an iPad.
It's not
So
doing
sometimes
iPad
you can,
things.
if I do that, you
Yeah.
can actually.
Oh, you did something there.
Yes.
Just don't break it.
No, that's all right. So,
I never did this. Oh, you're good. That's kind of what they asked us to do, isn't it?
yeah. It's still not coming back.
When you call and you don't get a quick
Yeah,
answer,
I know.
it suggests
It means that there's a lot
everyone's
of
having
drama
a problem.
going on at the
Yeah.
moment. So, because once I had to reset it and they just.
Yeah. See, there could be something in the background
Yeah.
happening to the whole unit.
I'm not sure why.
So if you do that, you've got to get right to the edges
Yeah,
of the
so
screen. Yeah.
usually when you on some of
Yeah.
them it works because I once had them come out and reset it.
Yeah. So they just did the really obvious thing.
Yeah. So but I'm not sure. Device text network or edit the settings to the manager.
If not, I'll have to go to the Ostley cases. But guess what? Ostley was down this afternoon.
It's on. I was there on it before, so it's working.
Hi, I'm in the Masson Theatre in chemistry, and the control panel has lost connection to the rest of the system. Yeah, okay, sure. Alan March. A-L-A-N. March, as in the month. And do that iPad drag thing. Yep, we did that actually. Yeah. So,
5-finger swipe.
yeah, okay. Oh, now it says room disconnected, tap screen to connect.
But then it just brings up that.
Yep. Yep. Yeah. Settings. I've got connection error, retry room manager cancel in front of me right now. So drag again. Come on, boost.
No, it's not.
It's not doing it. Rooms, no. All I've got is room disconnected. Oh, now I've lost the edges on it. There we go. It's got written chemistry Mason Theatre, that's a misspell. Rooms, and I've got a little upload or bookmark symbol on the side. It's going to flick up. Let's put the application. Just you. Yeah. Oh, the top of the screen. No. No. Yeah. While you do that. Sorry? Oh, it's spelled Mason, M-A-S-O-N, whereas I think the correct spelling is Masson with a double S. So it says Chemistry Mason Theatre on here. Oh, good. So you're remoting into it? Okay. So we've got
Got into the control,
control.
but it's not letting us do anything.
So while you do that, I'm going to see if I can find a way to do this without... Because I just wanted to use the document camera and flip between that and flip between the computer and the doc camera. So I'm a bit stuck because I was relying on... Oh yeah, it did change it. My trouble is that I want to flip back and forth as I read through stuff. Yeah, that'd be great. Yeah. Okay. Cheers. Thank you. Bye-bye. Okay, guys. Sorry about that. This little device, which I never knew was actually an iPad, has stopped working. So someone's coming. So we will run with the document camera, and we're going to run through some relevant bits of this hearing. And it's quite an important one, and probably the driving principle is this question of an apprehension of bias. So, you know, a suspicion or a strong possibility of bias in the conduct of a panel hearing. So where does it sort of go to about there? Can you read that still? No? Okay, so that small text is not the typical one. So, all right, so let's have a look here. We're in VCAT. And you can see there's a summary of the catchwords there. And if we look here, section 39, and I do have a hard copy here, so that might get me through. Who knows what section 39 of the Act is about? Defects in procedure. And I kind of go on about this one a little bit because this is something, if you are a planning officer or a consultant or, you know, some role, you might be a panel member, whatever, you do not want your process to be challenged on a defect of procedure. It is not a good look and could potentially be very expensive. So this gives anyone, look at the words are there, substantially or materially affected by the failure of a minister, a planning authority or a panel to comply with Division 1 or 2 or Part 8 and da-da-da. So basically not running the process in accordance with the steps set out in the Act. So you really need to be aware of these principles and how they're applied. So this one happens to be about an apprehension of bias. So who's it between? Mildura City Council, the Minister for Major Projects, the Minister for Planning as well, and you'll probably see right to the cut to the chase, the reference to the tribunal is dismissed, which you'll see means that this apprehension of bias was not considered a bias. So we're going to have a look at a couple of different angles on this. So if you know planning barristers, and in particular SCs, SILKs, Senior Counsels and SILKs, QC is the old name, Queen's Counsel. These are the top of the top barristers. They might cost $10,000 a day. You didn't mishear me? $10,000. It's expensive. Yeah, and if you see them work, you think, wow, they might even be worth it. Amazing. So it's, you know, if you're into that stuff, yeah. They can make black, white, black. So day, night, you go on. But, okay, Adrian is often a contributor to this subject, actually, but was not able to come this semester. But, okay, so the quick facts, not hugely relevant, but it just gives it this reality, I suppose. Victorian government wanted a waste containment facility, a hazardous waste in the northwest of the state, in Nwingi, and so without going through everything, they needed to appoint a panel because there was an amendment associated with the process. And the main thing to look to is that in appointing panellists, there was a concern that one of the panellists, in fact, the main panellist, the chair, Bill Russell it is, might not bring an impartial mind to the process. So Bill actually used to work here. And he's a nice bloke, very intelligent guy. But because he has opinions about things, based on evidence, I might say, the opposition, who were just really trying to oppose the facility, brought these matters up to have a go, essentially. So without going through it too much, you know, he's worked for Labor governments and he's worked for state governments and he's done this and done that. And so they basically use this as an attempt to stymie the process, to stop the process as it proceeded. So, what are the issues here? And you'll see that the tribunal member, and in fact it's worth pointing out, Justice Stuart Morris, who's probably the most famous planning lawyer, and actually studied here, not under me, he's a lot older than me, is sort of presided over this, so to speak, because of the importance of the case. So, the requirement to accord natural justice is a defining aspect of the legal obligations cast by administrative law upon decision makers. And in fact, there's a specific reference in our Act, section 161(1)(b). So, it's the law, so we're taking this seriously. And one of the key things that comes out very quickly here, natural justice is a doctrine of indefinite scope. It should not be thought that the content of the obligation to accord natural justice is universal. Rather, it depends on the context and the circumstances. So that means we have to use our professional brains. We can't just say that's in or is it out, and which adds another extra little flavour to this. You must consider the circumstances. I will skip through a lot of stuff here. But we're calling this the apprehension of bias principle. That's an important one. And a few key things come up. And if you recall, I made a bit of a song and dance about the panel being different to a court of law. And this drives a considerable amount of this, insofar as the way the panel is understood to normally operate as a bunch of experts making good decisions is a bit different to a court of law with a judicial officer, and they wouldn't appoint the judge as someone who'd had all these crazy opinions. That's why you might note judges don't go and do all this other consulting work, do they? Because it would make it impossible for them to do their job, if you hadn't thought about that one. Okay, so that was a key point. And here you'll see Hayne, in a previous court case, he had said, other decision makers, however, may be under no constraint about taking account of some opinion formed or fact discovered in the course of some other decision. He's basically saying that panels operate differently, whereas if it's in a court case, it steps through and they can only consider things that are directly brought to them, rules of evidence apply, all that sort of stuff. So, they go through, you know, what is a panel hearing, how do they operate, etc. How does the minister appoint them? It's actually very instructive as a case to learn how panels work, if you're wondering, you know, exactly what goes on under the bonnet or in the black box. So, talks about Planning Panels Victoria and what they're meant to do, and I'll let you read those things under paragraph 20. But then we get to some of the nitty-gritty. The application of the apprehension of bias principle in respect of panels. In my opinion, now this is Justice Morris's opinion. So he's the big planning lawyer in charge of the planning list of VCAT. In my opinion, the apprehension of bias principle to be applied to panels under the Act must have regard to the administrative and policy role of a panel, and so forth. The panel appointed under the Act diverges significantly from the judicial paradigm. So he talks more about that. Hello, sir. Well, thanks. And panel members are appointed ad hoc, not uncaringly, but as required, when they mean ad hoc, you know, as needed. And the panel is an expert body, as in we get experts and indeed people who are used to this application of evidence and use of policy as circumstances apply, as in, you know, they're not just robots, they are exercising their professional and expert discretion as they do that. And there's reference there to a court case run by Lord Hope. The fact is, the bringing of experience to bear when examining evidence and reaching a decision upon it has nothing whatsoever to do with bias. It's basically saying his other jobs, where he did express an opinion based on that particular job or role, doesn't mean he's going to be biased in this different case. So that's important. And indeed, it is not uncommon for experts in the planning system to have opinion that could look like it's against development over there based on the evidence, and for development over here based on the evidence, because it's meant to be more sophisticated than just against or for. It works. Can I try it? Not that I don't trust your expertise, just the law we're looking at there. Okay, thank you, sir. Okay, so, go back. What have I done? There we are. All right, so they talked about how he's too involved with Labor governments and all this sort of stuff. Actually, he was, giving them advice and expertise and things like that. In going through it, Justice Morris noted, Dr. Russell does not always give advice the government may wish to hear. He looked at his record effectively. And then if we cut right to the end, we will see, he went through all the processes properly. They contested it. He responded. Basically, he said, no, I don't believe there is an apprehension of bias. Will continue. And we get to the end. It has been convenient to deal with various bases upon which the application is made separately. Oh, hang on, wrong bit, Alan. And, the end of it is actually on the front cover, but yeah. So they're all the order. The reference to the tribunal is dismissed, as in there is no apprehension of bias under section 39 or 161. So we're dismissing this attempt to discredit his independent view in this case. So that's sort of one version where an expert is doing their job, and indeed the planning system would fall down very, very quickly if professionals weren't allowed to give their opinions on a case-by-case basis. So let us remember where we're up to over here. Okay, so that's the bias rule. Then we've got the hearing rule. Basically, the hearing is about how the hearing is conducted. So just going backwards, bias is the person running it and making decisions in it. I'm getting overexcited, thank you. So the bias rule is about the conduct of a panelist or some other person running things, making sure the processes are followed. And then we've got the hearing rule, which is how the hearing is run and making sure everyone got a fair go. As one case, if you look up fair suck of the sauce bottle in the High Court, sort of characterised it in a very Australian way, as in, fair crack of the whip. So if we now look at Winky Pop, and think about what it means to run a process properly and to give people a fair chance to have a say in a panel, not in the VCAT, not in the tribunal, in a panel, because of course we know they operate a little bit differently. Yay, I feel a little success each time. So we're in VCAT, and you'll see again section 39, principles of natural justice applicable to planning panel hearing. Okay, again, super important in the conduct of what you do there. And so it's Winky Pop versus Hobson Bay Council. Why do so many of these cases have weird names? It's because people call their little business strange things. Surprisingly common. because there's only so many names out there, so they'll come up. I've had some crackers, some that are a little bit blue, to be honest, but anyway. Adrian Finanzio, another one of our friends. Raghu Appaduri, he's another one of our friends. So it's a small world, I guess. So reasons. The application under section 39, defects of procedure. And it's about an amendment which is basically changing, potentially, zones and overlays and other things in the planning scheme based on a new industrial land management strategy, as in why is it happening. And the applicant, in this case, this is the applicant under section 39, the person who's bringing that action that there has been a defect of procedure. And there's some other things that I'll ignore about costs. We'll have a quick look at them in a minute. And essentially, who was this? Mark Dwyer, another important dude. The hearing brought before me therefore concerned only the first, relating to the planning hearing process. The allegation relevant is that Amendment C33 failed to afford the applicant procedural fairness and a reasonable opportunity to be heard in the panel, and that it favoured submissions made by Mobil, as in the large petroleum company. So, I suppose we would be concerned if large petroleum companies did rule the roost. However, as we go through this, and I'm sort of skipping through fairly quickly, the issue is therefore essentially whether the panel afforded natural justice to the applicant, as in he's a small landowner on the edge of this industrial strategy area that Mobil happens to be in as well, and made its own submissions. And in particular, the applicant's contentions as to what constitutes a reasonable opportunity to be heard, as section 24 of the Act requires, must be measured against the circumstances of the case, the legislative framework and the subject matter of the hearing. So here we're saying, okay, it's relevant to the nature, the scope, the matters at hand. It's not just was he heard or not. And in fact, that is really what it all rests upon. And so if you work your way through all of that, and I've just tagged the main things, despite the circumstances of the case being somewhat complex, I believe much of the applicant's case on this ground is disingenuous to the panel that the applicant well understands, and where it was given a reasonable opportunity to express its views and comments from others. Basically, they're saying the applicant's been slightly tricky here and saying, I didn't understand what was going on. Actually, they're quite experienced in these matters. And talking about the circumstances of the case being very important for understanding whether natural justice has been seen to be done, and a whole bunch of cases referred to, and shows us where there's lots of links back into natural justice under the Act, the Planning Environment Act. And here we get down to brass tacks. Putting other issues aside, the Planning Environment Act does not require that each submitter to a planning scheme amendment be provided expressly with a copy of the submissions of each other submitter. They can get access to them, they can sit through the hearing and hear them all. In this matter, it was incredibly complex. Lots of documents, a lot of documents came in late. It turned out, I didn't highlight it in here, it turned out that the lawyer representing the applicant only came for about half an hour and missed the rest of the hearing anyway. So there's also a bit of a requirement for someone to actually make their own attempt, I would say, to be aware of the facts, and not everything can be provided to them in this circumstance. So actually they were being a little bit on the tricky side. And they're talking here, we think it's biased towards Mobil because you paid attention to their letter, they submitted a letter and things like that. Well, sure, but that's not an indication that we didn't afford you natural justice. So, and in the circumstances of the case comprising a broad policy review, it it is not the panel's role to indicate to each submitter before it of all the nuances of all the material that might have been discussed over preceding hearing days when the submitter was not present. So, so I think that's pretty clear. So, and here we go. Fair crack of the whip. So, the applicant under Section 39 was not disallowed to be there. They could have made themselves aware of the facts. They were not excluded, and in fact, it refers in other parts that their views and opinions were taken into account. So basically, the finding is that basically, I declined to make the declarations or orders sought by the applicants, the people who were saying there was a defect. Okay, so while there's great concern to exercise natural justice and to run the process properly, on the other hand, there's kind of a limit to it. And this test of reasonableness does prevail in many ways as well. And the Wensbury case, if you want to look that up, it's from 1948, I think, does go through a lot of that in some detail. And in British law, there's the man on the Clapham omnibus, as in just what would a normal dude, normal person say in this circumstance as a measure of reasonableness. So in Australia, it's the Wensbury case. Okay, so moving along kind of rapidly now. Back here. This is fun, isn't it? Okay. So that's the hearing rule. Panel reports, I won't go through this exhaustively, but what does a panel do? It goes away after it's kind of harvested information and it's run the process. It writes a report and it submits it to the planning authority. That's council most of the time. It must be available to the public, made available to the public, and the planning authority must formally consider the report as in at a council meeting, and it must vote on it under the Local Government Act for decision making. And then it's got to decide what to do, because the panel report might have said there were problems, or it was good, or it should be changed. So the planning authority must decide what to do, and it's got some choices. It might just say, you know what, it's not worth proceeding. It's, no good. It might change it, or it might just say, no, we're going to charge ahead anyway. So there's a bit of case law around that one. I won't go to that now. And the planning authority, as in council, must adopt it, must make a decision to do so. However, it's got to go through this next step. It's got to go to the minister. So this is, the version of democracy we have here. Local government can't make these decisions on its own. It goes to the minister. And what do you reckon the minister's assessing the amendment against? What's the key test the minister's applying? Yeah, it's the VPP framework. And the Act, I suppose. It may well be that politics influences it a little bit. But on the whole, I can think of some cases where that might be the case. But generally speaking, it's just, does this fit in with the VPP framework? And particularly state policy and the nature of zones and overlays. Okay, so the minister can change it without actually telling anyone, as long as it doesn't transform it. And if they want to change it, they've got to give notice. It slows it down a lot. And if no changes, bang, off it goes, it approves, is gazetted. Okay, now this is one we've heard a little bit about in the last year. It's tabled in Parliament and it can be revoked by Parliament. I had never seen a case of that until last year. I don't know much about it. It's only happened once. Very interesting topic. Someone should do an assignment. Someone should do a thesis on that. Speak to me about that if you're into it. It would be really cool. Yeah, because it's kind of, no one knows what's happening. Because Parliament hasn't been involved in the triflings of scheme amendments until this period. I suspect we'll see much more. Okay, so defects in procedure under Section 39, defects in process, they are not defects in general law. So it's about the process, and I would also add to this, it's not defects in the exercise of its discretion of a merit matter. It's only about the process, not going through steps properly. Maybe that would include not telling people when you're meant to tell them through notifications, etc. So that's a good one to look at in that respect. Okay, so let's have a quick break and we'll do ministerial interventions and then we'll do assignment 2. 25 past, let's charge into it again. Don't take too long a break and I've got a bit to cover. Okay. Now, the minister. It is an important role, and in a sense, the law is kind of saying, okay, the minister's got to comply with the law, but we'll also give him or her these special powers. And you probably gleaned that the idea is to facilitate government being able to govern and conferring powers where it might be necessary to do things quickly or with significant power. However, those powers are not sort of all supreme either. So, okay, so ministerial powers, 20 Part 4 is a really powerful bit of the Act. It would be a very good idea to know that one well. And the key is that he or she, in invoking 20 Part 4, is not obliged to afford parties natural justice when determining to exempt a planning scheme amendment from the usual advertising and submissions processes under Section 20 Part 4 of the Act. There's a big, long case here, Grollo versus the Minister. That was one of the key cases we still look at. I won't go to that because it's kind of unwieldy, but a very significant case. The Minister is also allowed to make him or herself a responsible authority. That may invoke taking on all the responsibilities of the responsible, that's tautological, it may mean that he or she is bound by all those other controls, but it depends what power they're using. So if it is under 6101, you'll find that it does modify the other obligations of the Minister as a sort of a different kind of responsible authority, but you want to look carefully at that one. So, so it's generally about matters of state significance, matters for the wider community, that these powers are invoked. So the land at Pentridge, which is in Coburg, 8 k's north of the city, was a case where the Minister used these powers to try and push through a really complicated change to the planning rules to the zones and overlays for that heritage site because it'd been sitting there empty for years and years and years, wanted to manage the process. So it's that style of thing. The Minister also may step in, so before a council, that would be an RA effectively, makes a decision, the Minister may direct the RA to refer the application to the Minister under Section 97B. And here are a bunch of tests, and you'll see the kinds of words there. The application raises a major issue of policy, and the determination of the application may have a substantial effect on the achievement or development of planning objectives. So it might have relevance for everyone in a significant way. Decision has been unreasonably delayed to disadvantage of the applicant. Now, developers have been trying to work on that for years, and I'd have to say the Minister is generally careful not to let him or herself become a helper of developers to get stuff through. So I'm pleased to be able to say that generally. Another act might require an integration decision-making process. It might be the Emergency Management Act or something like that. I was working on something of that today. So the Minister may call in a matter that's before VCAT. So that's pretty significant. The Minister calls it in. So we call these call-in powers. And again, it's about these major issues of policy. An example might be, well, it actually wasn't quite at VCAT under this one, when the RA was considering it. I acted for the Fox, sort of, you know, Lindsay Fox, who you might know, major trucking magnate, and he's got a mind-bogglingly beautiful sort of compound of houses for his wider family down at Portsea, and he owns that land on one of the old pre-Torrens land titles, which means he kind of owns the beach. Wow. So, because normally in Australia people don't own beaches, so he owns it to the high water mark, and so that was all complicated. And then the reason he was concerned to assert his ownership was just to keep it, but also he wanted to build a beach hut, like a bathing box. And then when I had a look at it, I thought, you know, that's not really a bathing box, that's a dwelling. Because, well, thinking of section 74, section 72, clause 72, you know, what's the definition of dwelling? It's got, you know, a sink and a kitchen and a toilet and, you know, all of those facilities. You know, so we had to take them out. So anyway, so these are the sort of cases. So the minister did call that one in because he, at the time, was concerned if people started to appropriate beaches being public land, it would be quite significant in this country. We've generally managed that quite well to not let that happen. So, all good fun. So the minister can call in things in front of VCAT, and these tests, you know, about interests of the state or part of the state or a major issue of policy have actually been used quite flexibly, some people would say. So it is with some care nowadays that ministers exercise these powers. There was a period into the early 90s where ministers were quite, probably Jeff Kennett was the one who really became first accused of constantly calling things in. I actually did some research in the late, well, it was about 2009, and actually all of them call things in at about the same rate. It's really interesting, but we were certain that Jeff Kennett had to be the worst because he was a terrible right-wing minister. Rob McClellan under Jeff Kennett. But in fact, they're all just as bad as each other in that respect. There have been some cases where it has exposed some very tricky behaviours of ministers. So if you want to look at Minister Guy, or the former planning minister who is now the leader of the opposition, Matthew Guy's work while he was planning minister, he did some things in Ventnor on Phillip Island that to a casual observer might just look like he simply helped a large developer rezone a lot of land. I'm not accusing him of any wrongdoing, but you may form your own opinion about that. So we had a look, you know, yes, there's quite broad powers for the minister, but it is not without limitations. Now, I had previously put the wrong case online, so you won't have read this. And I need East Melbourne, and I will find it now. Now, I've talked about it with such vehemence, I better produce the actual... Here we are. Now, this is sometimes referred to as the Hilton Hotel case, and it is a monster that you cannot see. Okay. All right, so East Melbourne Group versus the Minister for Planning, and essentially prior to the Commonwealth Games, so I'll put the correct one up now on the LMS, and it interestingly also sort of describes a lot of processes about amendments that can be quite useful, but it is a monster of a document. So, you know, don't try and read the whole thing. It probably won't yield results for you. So the essence of it is that there was a developer who wanted to develop a bunch of land around the Hilton Hotel in East Melbourne, and Council, which is the City of Melbourne, was getting very concerned about the amazing sudden amount of development occurring in that area, and was introducing an amendment with a design and development overlay which was limiting height in that area. The minister was Mary Delahunty, the former newsreader, and it was contentious. I'm choosing my words carefully. It was contentious about why she used her powers under 20 Part 4 to make an amendment rather rapidly. So let's have a quick look at that. And as I said, it's a monster of a case. So I'll take you to a few key bits, and we can extract the main components. So we are in the Supreme Court of Victoria for a start. And I'm kind of careful because a lot of my friends were involved in this. So, well, they're friends right now. See how I go. So, the dispute between the parties, so just remembering there was a tribunal decision. Actually, there's so much going on here. This is mainly, we'll ignore the tribunal decision because that was related but not pertinent to the principle I want you to draw. Let's just say there was concern that 20 Part 4 was wrongly invoked by the minister about Amendment C101. So in a sense, this was a clash of amendments. Council, from memory, had sought to limit height using Amendment C93. Just check my memory later, that might not be accurate. And then the minister came over the top of that with another amendment, C101, to facilitate the development of the Hilton Hotel and surrounds to higher than Amendment 93 was going to allow. Does that make sense? It's kind of complicated, isn't it? And in that process, the minister exercised her power under 20 Part 4 to exempt herself from the requirements of sections 17 to 19 of the Act. Notice. So if you have a look here, this is an excerpt of the Act from that time. It's basically the same now. The minister became planning authority under the Act, and this is 20 Part 4. The minister may exempt him or herself from any of the requirements of section 17, 18, 90 and the regulations in the respective amendment which the minister prepares if the minister considers that compliance with any of those requirements is not warranted, or that the interests of Victoria or any part of Victoria make such an exemption appropriate. So, was it appropriate? Becomes one of the turning points on which this rests. So I won't go through this in detail, but you can see the sort of things under sections 17, 18, 19, copies to be given to persons, all of those processes that we'd normally have to make submissions against it, and essentially that there'll be a panel that considers it very carefully whether or not it's a good idea. So, the plaintiff and the appellant is the person who's calling the case, the one who's complaining, essentially. They're the East Melbourne Group, an association representing residents in the area. And it's the defendant, as in the person accused of doing something bad, is the minister. I do draw some pleasure from that. Tough job. Okay. And the contention was that the minister's decision in relation to clause 101 was invalid, and submitted that the minister's subsequent exemption under 20 Part 4 was invalid because it was based upon the proposition that the development authorised by 101 would be completed by March 2006, so as to provide accommodation for visitors attending the Commonwealth Games. Interesting. So that was kind of the reason. We need more accommodation for the Commonwealth Games, as if that is a matter of state significance. Well, it may well be. Governments love these big events, and there's some reasons for and against. So they're saying, well, it is therefore void because that reason is not a good reason. And you can see, if you want to look up this, the background facts, you know, it goes through what the development was and all those things. It takes a lot of words to do that, so I'll ignore some bits. This is kind of something I explained briefly. Basically, the proposal did not comply with Amendment C93, which is the one limiting height in that area that Council, the City of Melbourne, wanted. Basically, from 15 stories up to 24 metres. You might see where this is going. Is this about providing accommodation for the Commonwealth Games, or is it about allowing a developer to build much higher than the 15-storey height limit? Okay, so a whole lot of stuff submitted, and in the interest of time, and some statements were made, such as the amendment is required to facilitate refurbishment and redevelopment of the Hilton and surrounding properties and restorations, etc., in time for the Commonwealth Games in 2006. The learned judge considered two main contentions raised by the plaintiff, that's the East Melbourne group, whether the minister's decision to exempt herself under Section 20 Part 4 was invalid because it was made on the basis that the development authorised by C101 be completed on time. Second, whether the minister's decision was invalid due to a failure to comply with the rules of procedural fairness by exempting herself from notice requirements. Now, poor old Mary, I think, didn't enjoy this much. It was very bad for her health, in fact. Here's where we invoke Wensbury. And it's this test of reasonableness. So if you want to have a look at that, I won't focus on that right now because it gets a bit complex, but reasonableness is in a lot of the wording of the Act. So you might just want to remember that that's there. I'm not going to examine you on reasonableness, but actually it comes up quite a lot. So you need to be aware of this Wensbury process in there. So, part one, we're nearly there. So, and I'm going to go just... Now, here is a principle that the learned judge is making. The minister should ordinarily be bound by the reasons given, insofar as, in 20 Part 4, he or she is bound to give reasons for invoking 20 Part 4. She said that it was to make sure the development was in time for the Commonwealth Games 2006. Two problems with that. It looked as if it was actually to allow a developer to be bigger, the development to be higher than the normal planning rules, and in fact it couldn't be ready in time anyway. So it was a pretty bad case that she was in at that point. And in our opinion, there was a single publicly stated reason for the minister's decision to exempt the amendment from notification. It was that urgent action was required so it could be in time for the Games. And essentially, it was shown that it simply was not the case. Improper purpose, irrelevant consideration. It's pretty damning, actually. So the conclusion we've just expressed is enough to dispose of the appeal. But for the sake of completeness, we should address a discrete argument raised, improper purpose and irrelevant consideration. The minister's reason for exercising the exemption consistently was the assumed benefit of having refurbished. And then they invoked the Wensbury principles, as in, is that really reasonable? And would the decision be vitiated if refurbishment of the Hilton Hotel was a purpose of the minister's decision? Vitiation means a defect. That means the process is wrong. So a vitiating error is an error which is fundamentally wrong. Yeah, that's as simple as you can put it. Okay, so this is really a really important case to go back to if you want to examine the use of reasonableness, what vitiation and vitiating errors mean, and I'm realising that time's going fast, and this is a good one. It is submitted under section 20, there must be a direct nexus between the planning scheme amendment, which is exempted, and the matter which is of state or regional significance, which is identified as the test for granting exemption in the ministerial practice note. So nexus means connection. So you can't use one reason, and it's not really the true reason, that you're facilitating the amendment with no notification powers or submission powers. And here's another rather damning comment. You know, this was submitted. Planning approval was not required for the refurbishment. That's true. It could have just been done without changing the height of the structure. So they were binding the two, conflating the two somewhat tendentiously, I might suggest. And then we're back to section 39(7) of the Act, as in, was the process run properly? Was there a defect of procedure? Okay. So, and there's a bit to it, but it is integral to the rule of law that persons affected by administrative decisions should have access to the courts to challenge those decisions. So privative clauses are strictly construed. Privative means, is there something important missing? There are a few big words in this, aren't there? Yeah, privative, as in something is not there which should be there, as in access by the general public to have a voice in this process through the normal submission and panel hearing. So the appeal was allowed, as in there was a defect of procedure, and the amendment to allow a height increase on the Hilton was not allowed. Whew. Okay. Okay, so one more to go. And I'm not going to go through all of it. Decisions made under the Act, under any Act, but the planning right must be made in accordance with the law. So we've got the decision and we've got the process. The powers conferred by the Act or the scheme must be exercised within the ambit of power. So you can't go beyond the nature of the power given by the Act. So an example might be making a decision about things that are not even part of a set of decision criteria, might be an example, or imposing conditions which are not really relevant to the matter being considered. And Shallot is a good case for that one. I knew we wouldn't have time for that one, and I won't examine on it, but it is on Shallot, but that principle is really important. And decisions made must be arrived at having regard to all relevant matters and disregarding irrelevant matters, open on evidence and rationally. And the East Melbourne Group is a very good case of that. You've already had a look at the National Trust principle. And last one to look at really quickly, in a way that ensures the processes contemplated by the Act have been followed. So, Cook, that's Cook. In short, it's about an objector, Ms. Cook, in North Melbourne, and there was a process run to build an addition at the rear of an existing structure, and notice was given, a decision was made, but there had been objectors. And can you grant a permit if there were objectors? Can you grant a permit immediately after making a decision? No, because you've got to issue a notice of decision. And what's the notice of decision for? to allow you to make an appeal. That's right, if you choose to do so. So, in this case, without going through all the, the various things, it turned out that the City of Melbourne had not issued a notice of decision to all of the parties. And one thing, this is too much to read, but if you want to learn about the Doug Wade case, which I mentioned a few weeks ago without actually giving it to you, or maybe I did eventually, but if you want a really good summary, it's this one. And so if you look in Cook, you'll find a really, well-written summary of the Wade case. And essentially, it's weighing up, it is measuring the amount of notice that should be given to potential objectors. And a key thing that comes out in this case is that in the Wade case, it was under one set of legislation. The Wade case informed this legislation, and this one is much more rigorous in making sure people have objection rights and indeed notice of decision rights. So, so we kind of moved from the Wade case way of thinking about the limitations to objection rights. So Ms. Cook took issue with not being given a notice of decision that she might appeal with. Oh my God. Sorry for invoking a deity, my apologies. So we're talking here, Section 87 also empowered the AAT and now this tribunal, because it's the VCAT, to cancel a permit if it considers there have been any material mistake in relation to the grant of the permit. So in this case, a permit had been granted but not acted on. And there's some commentary there that the situation is materially different to the Wade litigation, and particularly we have a new section in the Act that changes that up a bit. And so some commentary there, and I'll just cut to the chase. In my view, the planning merits favour the making of a declaration of invalidity. Someone say it for me. Invalidity. Oh no, it's too late. It's invalid. Okay. Invalidity. Oh, God. Okay. The tribunal declares that the permit issued by the City of Melbourne is void. You would have some very unhappy developers there. Very unhappy. And it was just actually a kind of a minor defect of procedure in some ways. Well, as in some letters weren't sent to the right addresses. So this is a really bad look. Really bad look. Okay. I'm going to finish off without going to another case because I'm a bit slow. Okay, so these principles, basically they apply to everyone who is using the Act. You know, the law applies. Jurisdiction, generally VCAT doesn't consider legal matters unless the Act tells it, and if that is the case, it has to be a legally qualified member of the tribunal to work in those ones. And procedural defects, Section 39. So I'll just skip over those. Kind of covered them anyway. The Supreme Court doesn't exercise its powers in merit, as in is it a good development or not. The Supreme Court only exercises its powers insofar as there is a legal defect. So you see all those cases we've been looking at, they are about a process that hasn't been followed properly, as in a process or requirement that is set out in the Act, making it a legal defect. Okay? So what the Supreme Court will do is send it back to the tribunal to make a good decision, or say the decision was okay. It won't make a merits decision at the Supreme Court level. Okay, so, oh, well, there, I've said it. And, yep, okay. Yep. I won't go through those. Okay, so, final things I wanted to talk about, the assignment 2. 2 things I would mention. More than 2, actually. One of them is that I have now put up the, I clicked the right box, and the discussion board for assignment 2 is open. So I'll attempt to look at that and respond to things every couple of days, if not more often. So everyone gets the same information. I guess I will admit it's more efficient for me. One way to move through the answering of the assignment question is to use a planning assessment template. In the 5 minutes I was rushing to the class, I couldn't find the exact one, but they look rather like this, okay? So if you look there, you know, they've got, you know, application, you've got all that information. What is the zone? What is the overlay? These are all the basics, and I'm hoping you know that quite well by now. Description of the proposal, what's the subject site and existing conditions, site area, existing, you know, what's on the land, you know. So this is a really basic sort of start through it. I will mention VicSmart is quite a truncated, short process. If you get the real planning assessment report, it's not terribly different, but it's got a few more categories to fill out. I'll go and find it tonight. I just couldn't find it. The Delp site's changed. Has anyone got that link handy? If they do, flick it to me. Okay. So that makes it a simple format. So I'll make sure you've got a copy of that link or that PDF, or well, you want a Word document, I guess. And the next page of that, you know, your assessment, what's your conclusion, what's your recommendation, the sort of things you would expect. But there has been a bit of a push to make the format relatively similar, just to make them easier to read for anyone. So that's one thing. The other thing I wanted to mention, just in brief, in my beautiful writing, is, don't laugh, I guess the evidence is there, isn't it? I could write legibly at one point, but it seems to have degraded. But I mean, what is this process of going through a planning assessment? And I suppose after you've done about 1,000 or more, as I have, I'm sort of thinking, God, it can't be that hard, can it? But it kind of is, I think, isn't it? So, you know, what are you really trying to do? Well, the first thing is, where is it? Let's add that on the fly. Where is it? You know? Now, where, if you can read that, is not always simple, actually. You've got to know the exact boundaries. And to do that, you would look at land channel. And what that does, it gives you a number of resources, the first of which is the cadaster. The cadaster being, you know, it's got all the lot diagrams and the roads and, you know, the basic legal boundaries of land. And you can put in an address and you get the exact location of that site. It's finicky though, it's got to be spelled exactly right. But also, you can also, through that land channel, and it'll take a few minutes to learn it, but it's not too complicated, you can find out zones and overlays. I would also recommend checking with Planning Schemes Online to make sure they are corroborated. There will be a new online platform probably in a few weeks, but so you might see the test version, the beta version up there. But so, you know, where is it is fundamental, but also one of the good things about that is you can take screenshots of land channel, cut and paste them into reports, you get the zones and overlays. You can also measure things off with a little ruler function, So we've got lots of stuff like that, just to make simple diagrams. It's quite useful. So when you know where it is, you must work out what planning controls apply as a fundamental starting point. The zones and the overlays. And sorry if I'm teaching some of you to suck eggs, but it's worth just going right down to the fundamentals. When I do this, it sounds really sort of obvious or basic. I get a blank bit of lined paper and I just write it all out. The address, the zone, the overlay, because if you get them wrong, the whole assessment's wrong, isn't it? Just make super sure you've got the right background stuff. And again, knowing exactly which lot it is might change the zone if you get that wrong. So get it right. What zones apply, what overlays, and then sometimes this is in conjunction with this one. What is actually being proposed? So is it an office? Is it residential or dwellings? That question is also fundamental to your assessment that you are making, isn't it? Because depending on the zone, some things need permits, some don't. Some things will require a certain test under the planning scheme because of a particular trigger for permit. Well, some things are just plain prohibited, aren't they? So you need to go through that quite systematically. Personally, I would work out all the zones that apply to the bit of land. Then I'd work out what's proposed. Then I'd work out the triggers for permit, and I'd go back to the planning scheme, because sometimes you think, well, actually, now I know what's proposed, there's under clause 5206 a certain car parking requirement for that, or a requirement for a loading bay. Stuff like that. You don't find that immediately, for example. So you need to work on that quite directly and instrumentally. What is the trigger for permit? Then, of course, what do? What are the decision criteria? And this is sort of getting down to the nuts and bolts, isn't it? Because that provides the test of whether or not it gets a permit, and possibly whether or not there are conditions that modify what has been initially proposed. Yeah? And then, what needs to be submitted with it? So sometimes you might need to submit a certain document that provides additional assessment. So you need to be aware of that for certain types of application. So you need to actively search for that. At the same time, what I would do is I would try and work out most of that, then I'll go and have a look at the place, knowing what it is that I'm meant to be supplying or assessing. Now, you guys are given a certain role in this, aren't you? You are planning officers for the purposes of this exercise. So you will see that a whole bunch of stuff has been submitted. But having been a planning consultant for about 15 years, I would recommend every single planning officer to form their own opinion. So sometimes the documents in there are high quality, other times they're a bit dodgy or they're misleading. It would be a rare planning consultant's report that doesn't say the development's really good, wouldn't it? So you need to go back to what is a trigger, because sometimes they're just wrong as well. You need to form your own opinion about how this application meets or complies or doesn't with the decision criteria that are invoked. Yep. And pull all that together, and then when you are, when you're doing stuff, say on this, your assessment is not about VicSmart, this is just an example, remember, will be against the decision criteria set out in the planning scheme. So, for example, if it were a heritage matter, a heritage trigger, you would be going through the decision criteria of the heritage overlay, wouldn't you? And you'd be saying, well, the proposal has a flat roof, where in all of the heritage properties in this area, it's a pitched roof. So that, doesn't comply. So whatever those criteria, you directly address them here. When I say directly, exactly, you discuss them. There will be some subjective values in much of it. That's fine, but you need to provide reasons for those. The other thing you can do is use a table as an appendix, and if there's a bunch of really detailed stuff, you might put the main points here and have a table as an attachment behind, if there's sort of like a list-based thing. And of course there's a recommendation, and this is a planning officer's report, and he or she is making a recommendation to council that a permit issue with conditions or refusal with reasons. Then the council will make a formal decision about it. So there's also, if you look at the DELPS, I'll provide a link to this, but DELP has a whole lot of planning officer reports relating to ministerial call-ins. So they give you a bit of assistance, but they're a little bit different to this template, but they'll give you some of the language and style anyway. Okay, so just thinking, and I'll put a copy of that, maybe I'll even type it out for you. So these are the sort of things that you're needing to bring together, and the process seems really tough, but and lots of state policy. So state policy is an interesting one, and I'm going to let you go shortly, but generally speaking, I would begin with these real fundamentals, zones, overlays, trigger for permit, and generally speaking, if something is directly within the specific controls, it gets a tick. If there is discretion to be exercised, we then look to state planning policy. But if you look at some example planning officer reports, what they tend to do is where's just a bit of a funny old. Normally there'll be another section here, and it would have relevant controls. And what is normally done, there is a brief summary of key aspects of the planning scheme, particularly state policy. So if you look at state policy, there's reams and reams of it. But what bits of state policy might have something to say about this site, about consolidation or location of higher density near good public transport, etc. So you summarise it in there, because who's the audience for a planning officer report? Councillors. So they don't want to read the planning scheme. They can already do that if they wanted. What they want to do is to read a planning expert's summary of the key things to look at. So they don't want to go through reams and reams and reams and reams. They want to know what's relevant to this matter. And they want a recommendation based on a clear reading of the planning scheme. So that's your job. One or two quick questions, and then I'll let you run. No, but you do need to contain the answer in the document, okay? But you can support it outside. So you need to exercise some discretion there. Have I answered the question? But if someone's going to wonder, how have I really done that, they can go and have a quick look and say, oh, yep, they got it. But don't write mobs and mobs and put them in tables as appendices or attachments. I know it's hard fitting it all in, but I also know it can be done. All right, thank you very much, guys. We covered heaps, but we're on the way. Cheers. Next week, we have Andrew Walker coming back. We're going to do a summary sort of session, bringing it all together. I'll send more info.